Number 6 topic is formalities. Formalities of hire purchase transactions or agreements. Then number 7 is termination and minimum payment clause. Termination and minimum payment clause. Under that, we'll look at section 8 of the Hire Purchase Act. Then lastly, which is number 8, we'll look at recovery by the owner and relevant proportion. Recovery by the owner and relevant proportion. We can find that under section 9 of the Hire Purchase Act. Now, these are the major topics that we're going to cover under these two broad subject matters of commercial law or business law. So we start with sale of goods today. Now, talking about sale of goods, the question here is, what is the nature of sale of goods? We have a law that is governing sale of goods in Nigeria. And that law is called Sale of Goods Act. Sale of Goods Act of 1893. So it is an aspect of transaction that is governed by a legislation. And that legislation is called Sale of Goods Act of 1893. Now, however, that act is not an all-encompassing act. It is not one size fits all act, as the act does not regulate everything there is to regulate as far as sale of goods transactions are concerned. So the implication of that is that even though the act is a codification of rules and regulations governing sale of goods, but a lot of other things are left open for the discretion of the buyer and the seller. And if that is the case, the implication is that common law rules also apply. Now, meaning that everything that has been taught by Akaya under law of contract, to a certain extent, will also be applicable to sale of goods transactions. For instance, principles governing offer, acceptance, consideration, intention to enter legal relations, and capacity, and so on and so forth, will also be applicable to sale of goods transactions to the extent that they are not excluded or prohibited or restricted by the Sale of Goods Act. So meaning that sale of goods transactions or agreements is a space that is governed by, on the one hand, the Sale of Goods Act of 1803, and on the other hand, common law principles or general principles of contract will still be applicable. So meaning that any gap, any lacuna not provided for or governed by the Sale of Goods Act, then parties or their lawyers can revert back to the general principles of law of contract, or what we call common law. So you need to understand the nitty-gritty or the nuances of sale of goods as far as its nature is concerned. Now, sale of goods is one of the everyday contract that people enter into. You see, sometimes non-lawyers believe that before you enter into a binding agreement, that agreement must be in writing. Now, with your experience in Akaya's class, you will have understood that that position has no backing of the law. You can enter into a contract any way you want. It can be oral, it can be verbal, it can be in writing, it can be by deed. In fact, you can enter into a contract by your conduct and it will be enforceable. So, and the bulk, more than 90% of contract that people enter into on daily basis, they are unwritten contracts. So, and yet they are enforceable. But the reason why people try to be wary about entering into unwritten contract or verbal contract or what is being called parole contract, in law of contract, is when terms are being disputed by the parties later, how do we bring evidence to show whether it is party A that is correct or is party B that is correct? Why? Because nothing has been reduced into writing. It is just my words against your own. And when we get to court, cases like that used to give us serious challenge in court, because you need to bring witnesses who will say, oh, I was there when they were entering into the contract, though verbally. I heard Mr. A said this, I heard Mr. B said that, and all that. And the other party also will bring his own witnesses also and say, oh, I was also there. And the cycle continues. And at a point, the court or the judge must draw the line somewhere. So apart from the problem of evidential challenges, the bulk of the contract that we enter into are informal contracts. So meaning that, especially when it comes to sale of goods, in fact, the bulk of sale of goods transactions are majorly informal contracts. You go to market, you buy items, you buy laptop, you buy a car, you buy fridge, you buy deep freezer, you buy furniture. Now, these are transactions governed by sale of goods act. Apart from them giving you receipt, will it not be ridiculous if you enter a public transport or you enter Uber and you are carrying Uber agreement and you are showing it to the Uber man? Please sign this agreement that you will drop me at Yaba and your fee is 1,000 naira. Now, the Uber driver will look at you like, are you sure you are okay? Because it is taken for granted that transactions like that, even though it's not in writing, it's enforceable. So you now understand when you talk about sale of goods, just means the law regulating buying and selling in a layman's language. The law regulating buying and selling. Now the question is, what type of buying and selling are we talking about? Especially in this our climate, where we buy a lot. We really, really buy a lot. We produce little, but we buy a lot. This our economy is a buying economy, and that is why it's always very difficult to draw a nexus between a person's income in Nigeria and his buying capacity. For instance, you see somebody in salary is 100,000 naira, is using a phone of maybe iPhone Pro Max 15. I think 16 is also out. His salary is 100,000 naira and he's using phone of 2 million naira, 1.8 million naira. His salary is 100,000 naira. His car is worth 20 million naira. And if you ask questions, we say it is the grace of God. Everybody seems to be living in the grace of God in Nigeria. So now, if you have that kind of economy that there's a very big buying power, we buy and buy and buy and consume, and we produce little to nothing. Now, you will understand that the law regulating buying and selling must be such that is effective and strong, so that any party uh, that suffers injustice can get remedy under the law. So now, if you want to go by the definition of sale of goods, the question is, what is a contract of sale of goods? What is a contract of a sale of goods? If you look at section 61 of the Sale of Goods Act, it says that a contract of sale is a contract whereby the seller transfers or agrees to transfer property in the goods to the buyer for a money consideration called the price. Now, the definition is simple and straightforward. A contract of sale is a contract whereby the seller transfers or agrees to transfer property in the goods to the buyer for a money consideration called the price. Now, let's break down that definition into different parts. Now, if you look at the opening sentences, it's a contract whereby the seller. Now, meaning that number one, who are the parties? We have two parties. We have the seller and the buyer. Now, it says the seller transfers or agrees to transfer property in the goods to the buyer. Now, what is the implication of the seller transfers or agrees to transfer? Now, what is the seller transferring? Said, if you look at the definition, it does not say the seller transfer the goods. No, it says it transfers property in the goods. So we have a bifurcation on ground already. We have number one, transfer of property in the goods. That's number one. Number two, agreement to transfer property in the goods, because that's the implication of the seller either transfers or agrees to transfer. That is, transfers, that is a sale. Agrees to transfer, that's an agreement to sell. So from the definition, apart from identifying two parties, the seller, the buyer, the next thing you identify is two things: a sale on the one hand and an agreement to sell on the other hand. A sale on the one hand is the proper contract of sale, and it implies the seller transfers. That is, the transfer of property is immediate. What we normally call in a layman's language, cash and carry. Transfer of property is immediate. As I'm transferring the property and the goods to you, the contract is a done deal. The contract is a what? It's a done deal. I have sold to you. Property has moved from the seller to the buyer. And for proper understanding, I said that what is being transferred under the definition is not necessarily the goods, but property in the goods. The question is, what is property? Property simply means ownership, title, or interest. That is the interest the seller has in the goods, the ownership the seller has in the goods, or the title that he has on the goods. So that if you approach me and I want to sell a car to you, now in the eye of the law, once I sell the car to you, it does not matter whether you have taken delivery of the car. But once our intentions are clear that you become the owner of the car immediately. Now, even if you leave the car with me, in the eye of the law, property has moved from the seller to the buyer. Property has moved from the seller, that is title, ownership has moved from the seller to the buyer. So it is a sale, an outright sale. An outright sale. So when passage of property is immediate at the time of the transaction. Then the second is agreement to sell. Agreement to sell implies that, yes, both parties, they have agreed that property will move from the seller to the buyer, but it is not immediate. Property may not move until a later date, or property may only move subject to some conditions being fulfilled. So meaning that until the expiration of the time, it is still an agreement to sell. Until that condition is fulfilled, it isn't an agreement to sell. It is not a sale yet. So that if I approach you as a car dealer for a car, say Toyota Highlander 2017, and you say, okay, the price is 22 million naira, no problem. And having looked at the car, you love the interior, you love the body, you love everything about it. But when you now open the bonnet, you're like, this engine is looking new. However, you know what? Let me tell my mechanic to come and check the condition of the engine tomorrow, because everything is looking new, everything is looking nice, but I'm not a mechanic. So I will call my mechanic, he will come and look at the engine tomorrow. Then after that, I will make the payment. Now, on a good day, it should have been a sale, an outright sale, but it's not a sale, it's an agreement to sell until the following day when the mechanic comes around, checks the engine. If he checks the engine and the engine is good, then it says you should pay, then it becomes a sale. But if you test the engine and say, oh, I'm not advising that you should pay for this car because of the condition of the engine, then the agreement to sell will fall through. That's the end of uh, that's the end of the transaction. So it is an agreement to sell when passage of property from the seller to the buyer is not immediate. Maybe because a later date is agreed upon or is made subject to a condition. So until that condition is fulfilled, that is when the agreement will not become a sale. Or until that time elapses, that is when that agreement to sell will not become a sale. And the implication for distinguishing between a sale and an agreement to sell is such that under the law, risk and property, they go together. Risk and property, they go hands in hands. So meaning that he who has property has the risk, and he who has the risk has the property. So you can now understand why it is important to draw the difference between a sale and an agreement to sell. Now, if it is a sale, using the same car, the car dealer's example, you come to my garage or you come to my office, you have seen the car display and you're okay with it, you have checked the engine, and you are saying, I am buying it now. Now, that is a sale. So meaning that ownership is moving from the seller to the buyer immediately. Now, if for whatever reason you now say, okay, I will come and take it tomorrow. If anything happens to that car before the next day, and it is not my fault as the seller, then because ownership has moved from the seller to the buyer, it is the seller, it is the buyer that will be liable for the loss. The seller will not bear the loss. Why? Because property has moved from the seller to the buyer, and it is he who has property that bears the risk. However, if it is within the context of agreement to sell, that will not be applicable. Why? Because in agreement to sell, property has not moved from the seller to the buyer. So if you go back to the same car dealer uh, example, he views the car, he likes it, but he says, my mechanic will come tomorrow to check it. If before mechanic comes tomorrow to check the condition of the engine, the car is stolen or damaged, the buyer is not responsible. It is the seller that will be responsible. Why? Because property has not moved to the buyer. Therefore, there is no risk or loss to be suffered by the buyer. So you can see the importance of drawing the line between a contract of sale and an agreement to sell. Now, if you look at the definition again, it says contract whereby the seller transfers or agrees to transfer property in the goods to the buyer for a money consideration called the price. So meaning that the sale of goods act is clear about what consideration is. You see, under your general law of contracts that you have been taught by Carl before now, the case of a Corey and Misa, I believe that you have been taught that case. What qualifies as consideration can be anything. It can be in money, it can be in kind, anything that has value. In fact, your time, forbearance, detriment suffered, everything, anything that has value in the hands of the law. And the case of Korea Misa defines consideration as right, benefit, interest, accruable to one party, and on the other hand, the forbearance, the detriment, the loss suffered by the other will qualify as a consideration. So meaning that consideration under general law of contract can be in kind. Can be in kind. That's why in the case of a Eunice versus Chidak, in the case of a Eunice versus Chidak, it was a case that really analyzed the nature of consideration under law of contract. It was a case of Mr. A who borrowed money from Mr. B. And when the time to pay eventually reached, Mr. Hay, who borrowed the debtor, Mr. Hay, didn't have money to pay. Then Mr. B, the creditor, threatened to subject him to enforce the repayment. Now, at that point, Mr. Hay, the debtor, issued a check. Now, Mr. B, the creditor, tendered the check, but the check bounced. Now, that further enraged Mr. B. And while they were, quarreling and fighting over it, Mr. C intervened. And Mr. C pleaded on behalf of Mr. A, the debtor, that Mr. B should not worry, that he should grant additional time for repayment. That if Mr. A does not pay, he will personally pay for it. And based on that, the creditor sheathed the sword. The extended time for payment elapsed again, the debtor didn't pay. And what the creditor did was that he didn't bother to go to the debtor anymore. He just went straight to Mr. C, who undertook for Mr. A that he would pay, and started enforcing repayment of the money against Mr. C. And they dragged themselves to court. And Mr. C said, "My lord, I'm not a party to the contract." And the law is very clear. Anybody that is not a party to a contract will not be bound by the contract. And that he has not furnished any consideration. That is, the creditor did not furnish any consideration. So why should he now be responsible since the creditor didn't furnish any consideration? And the court said, "How do you mean by the creditor has not furnished any consideration? The debtor that you undertook for, he gave a bounce check, which the creditor had the right, as at that time, to report him to law enforcement agency because it was a criminal offense. But because of your intervention, he forbore. So, and that is why you see consideration as part of forbearance, covering forbearance. He forbear. That's why he decided not to go the route of a law enforcement because of the intervention. That forbearance was enough considerations. That is, when you have ability to exercise a right, but because of somebody's intervention, now say, okay, I'm not going to exercise this right because of your promise. Now, you not relenting on enforcing your right based on the promise given by another. The law said that is so. You can see different dimensions that consideration can take under law contract, but all that will not apply under sale of goods because Section 61 of Sale of Goods Act has made it clear that consideration must be money consideration called a price. So meaning that anything other than money will not be accepted. So the law does not care about forbearance, uh, detriment, loss, or whatever. No, you must pay money for what you are buying. So, and again from this definition, you will understand that sale of goods is all about one thing. And that one thing is determination of when property passes from the seller to the buyer. When does ownership pass from the seller to the buyer? When does property pass? When does ownership, interest, or title pass from the seller to the buyer? Ability to determine the time that it passes is what determines who will bear liability or loss that occur in the course of the transaction. And don't forget that The fact that you have possession does not mean that you have property. And the fact that you have property does not mean that you have possession. That is, when it comes to sale of goods, the law is not really particular about who has possession. You may have title over something, and that thing is not in your custody. That thing is not in your custody. Or you may have custody of something, but you don't have ownership of it. So if you have title, say you want to sell a car and the car is in your mechanic's place, but the title document to the car is not with your mechanic. So you don't have possession of the car at the moment, but you have ownership of it. So you can sell it to a prospective buyer and you'll transfer good title to that buyer, even though you yourself don't have custody of the car. However, on the other hand, the mechanic who has possession of your car does not have title to it, so that he cannot sell it, because though he has possession, he has no property. He cannot sell it. So the concept of property is different from the concept of possession. So somebody can have ownership of something, doesn't have possession, but can still transfer good title to a buyer. While somebody has possession or custody but does not have title, he cannot transfer a valid title to another person. Now, having dissected the definition of a sale of goods under Section 61, the next thing we look at is the subject matter of sale of goods itself, which is goods. The subject matter of sale of goods is goods. Having identified the parties, having identified the need to distinguish between an outright sale and an agreement to sell, having understood the concept of property, and having understood the nature of consideration that is allowed under Sale of Goods Act, and also identifying how crucial it is to determine when property passes from the seller to the buyer. The next thing is, what is even sale of goods? What is it all about? Now, for the purpose of business law and for the purpose of sale of goods, the subject matter of a contract of sale is goods. And the same section 61 defines goods as all charters personal. All charters personal, other than things in action and money. All charters personal, other than things in action and money. But it includes embezzlement, industrial grain crops, things attached to or forming part of the land, which are agreed to be severed or removed before the sale or under a contract of sale. Now, that's a pretty long definition. But again, we dissect it the way we have dissected the definition of a contract of sale. Now, if you look at the definition again, it says goods simply means all chattels personal, other than things in action and money. Let's first stop there. You know, as I said earlier, we'll try as much as possible not to bore you with all our legal jargons, our legal terminologies and that. I will try as much as possible to be simple about the language, but unfortunately, this is how the words are used in the the art. But I will try and give you a simpler substitute. Say all charters personal, other than things in action and money. Now, chartered personal simply means personal items. Personal items. Charters personal. That is, items that are personal to you. Items that are personal to you. Personal items. Now, talking about personal items, you know what personal items are? Items like your phone, like your bag, like your shoes, like your clothes, like your car. The list is endless, but there are things that are personal. In fact, under the law, it even includes animals like your pet. So you see that the list is unending. But what is important is that it must be personal items. Personal items. It must be personal um, items. Please, the definition is found in section 62, not section 61. It's not the correction, section 62 of the Sale of Goods Act. Now, all charges personal, all personal items, but it says other than things in action. Now, that is except things in action and money. Now, what are things in action? Again, that's another legal jargon. Things in action simply means intangible items, intangible properties. And when we talk about intangible properties in law, they are goods or items that are invisible, that are not tangible. They are not capable of being physically possessed like personal items, like tangible items. You can physically possess your car, you can physically possess your pet, you can physically possess your clothes, your shoes, and everything because they are personal and tangible properties. But things in action are intangible items that are not capable of being physically possessed. They are things that you can only enforce as a right in the law court. Yet they are properties. Like for instance, your copyright, for instance, your patent, for instance, your trademark, your industrial design. It also includes your shares, debentures, all those things. Even though when you buy shares in any company, they give you share certificate. It's not the share certificate that is the shares. Shares are invisible. Debentures are also invisible. Copyright is invisible. Patent, you stumble on an invention and lo and behold, you are reaping a lot of money from it. It is invisible. Some form of document can be given to you to prove that you are the owner of those things. But those things, the documents are just a mere evidence. So if anybody now infringes on your copyright, infringes on your intellectual property, then the next thing to do is to report to appropriate authority so that your right in that intangible property can be enforced against that person. So it says other than things in action, then also other than money. Money is not a subject matter of sale of goods, meaning that the law does not recognize money as goods. However, we have an exception to money. Money is not goods if it is still a currency. If it's no longer a currency, that is no longer current, then it can become goods. For instance, old notes, those coins that we used in the 80s. I don't know when last did anybody see coins in circulation. All those old 20 naira notes, 10 naira notes, 5 naira notes, 1 kobo, 2 kobo, 250, 250 kobo, 5 kobo. They have become antiques. Now, if you sell those old notes as artifacts, then they will qualify as goods, but not the current money that we are still spending, which is still a currency. It will not come under Sale of Goods Act. Other laws can apply to it, CBN regulations, foreign exchange, and all that, but not Sale of Goods Act. So it does not qualify as goods. So you can see from the first part of the definition all charters personal other than things in action and money. That is, all personal items except intangible items and money. All personal items, and emphasis on the word all personal items except intangible items and money. That is one hand. Now said it includes number one, embezzlement. Number two, industrial grain crops. Number three, things attached to or forming part of the land which has been agreed to be removed or severed before the contract of sale or under the contract of sale. Now, that is another level of legal jargon here. Now, we'll break it down. It says number one, embezzlement. Embezzlement is spelled Emblements. Again, Emblements. Embezzlement. Now, what are embezzlements? It's very simple. In a layman's language, it simply means annual growing crops. Annual growing crops. So it's defined as product of the land which do not grow naturally, but they grow by human labor. They grow by human labor through agricultural endeavor, and they run within 1 year. They mature within 1 year. So in a layman's language, or simply speaking, embezzlement simply means annual growing crops such as maize, vegetable, potato, any crop you plant that matures within 1 year will come under embezzlement. But you need to note, it does not include crops that grow naturally. There must be human industry. You have to get the seed, you have to plant it, you have to till the ground, then it must mature within 1 year. That is embezzlement. So the scope of goods covers embezzlement. Number two, industrial grain crops. Now, another word or name for industrial grain crops is fructus industrialis. Fructus industrialis. Fructus is spelled Fructus. Then industrialis, Industrialis. Fructus industrialis. Now, what does that mean? It simply means industrial growing crops. Industrial growing crops. That is, crops that grow through human labor, however, do not mature within 1 year. That is, it takes longer period than 1 year to mature. So industrial grain crops. So crops like cocoa, rubber, cashew, mango, coconut, plantain, banana, and so on will come under fructus industrialis, industrial growing crops. Then the last one that comes under the definition of goods is things attached to and forming part of the land. And another name for things attached to or forming part of the land is fructus naturalis. Fructus naturalis. Again, fructus naturalis is spelled Fructus. Fructus. Naturalis. Naturalis. Fructus naturalis. It simply means things that grow naturally. Things that grow naturally on the land. Now, and that's the difference between this category of goods and the earlier ones we have discussed. This, it grows naturally. and it is firmly attached to the ground. So things like timber, grass, even including mineral resources deposited under the earth crust will come under fructus naturalis. So things that you don't plant, rather they grow naturally. Things like timber, grass. Now, even things that don't grow, rather they are like mineral resources deposited under the earth crust will still come under fructus naturalis. But the only caveat with this category of goods is that you cannot, they are not a subject matter of buying and selling until you have removed them from the soil. If it is timber, you must have felled the trees. If it is grass, you must have harvested them. And if they are mineral resources, you must have mined them. If it's gold, if it's silver, you must have mined it and brought it out. It is after you have removed them from the soil that they become subject matter of sale of goods. While they are still firmly attached or buried under the earth, what you are selling is not goods. What you are selling is land. And sale of goods does not apply to real property. Landed property does not qualify as goods. We have another area of law that governs buying and selling of land, which is land law. So sale of goods does not include real properties. So if you are selling things attached to or forming part of the land before you remove them, what you are selling is not goods. What you are selling is land. And sale of goods does not apply to land. So you find yourself under the category of a different law entirely, which is a land law. Now, having explained this uh, dynamics of a sale of goods for foundational understanding of what sale of goods is all about, the next thing we look at is what are the classifications of goods? What are the classifications of goods? That is, how do we classify goods? How do we categorize goods? We have about 5 major types of goods. Number 1, we have specific goods. Number 2, we have ascertained goods. Number 3, we have unascertained goods. Number 4, we have existing goods. And number 5, we have future goods. And please, for the purposes of this class, and also for the purposes of exam, you need to understand that there's a nexus between classes of goods on one hand and contract of sale or agreement to sell on the other hand. There is, even from the explanation or definition of each of these categories of goods, if you look at this very well, you can know whether under each of these goods, the kind of transaction you can carry out, whether it's going to be a sale or it's going to be an agreement to sell. And these are the little areas that your exams or your exam questions can hide under. So meaning that the nature of a class of goods can already tell you whether that good will accommodate sale or it is only agreement to sell that can accommodate. It will tell you whether by nature of that goods, property is passing immediately to the buyer from the seller, or there is no way property can pass at that instance from the seller to the buyer. So when we explain types or classes of goods, it is not just for the fun of saying this is specific goods, but it is for you to look at this very well by the nature of this category. What type of transaction will this type of goods accommodate? Will it be a sale? Will it be an agreement to sell? Can property pass immediately from the seller to the buyer on this type of goods? Or property will not pass until much later, so that each parties will readily know their rights and their responsibilities. At that instant, they will know who will bear the loss in case anything happens, who will bear the damage in case anything happens. Now, we'll look at the first type of goods, specific goods. Specific goods simply means goods that are identified and agreed upon at the time of sale. The goods that are identified, number one, and agreed upon at the time of sale. Now, the implication of that is that specific goods can only accommodate a sale. Why? Because the goods have been identified and it has been agreed upon. What else? Property is moving from seller to the buyer. So if you now fail to take delivery of the goods as a buyer, that is your cup of tea. So if you go to Yaba Market and you enter a boutique and you identify clothes that you love to buy, and having bought them, you pay for them. You now say, customer, please, so I'm leaving this my bag containing the clothes I just bought from you. I'm leaving it in your shop. I want to go to another shop down the road to buy more items. You go away for 2 hours. Before you come back, fire has erupted, burned the shop, or thieves have burgled the shop of the seller and they have carted away your things. The law is very clear. You have perfected the transaction. The owner of the shop owes no responsibility to you anymore, even though you left it in his care. So you are the one that will bear the loss, not the seller. Not the seller. But if the good is damaged before you come back, the only way the seller can be responsible is if you pay him for helping you look over your item that you have bought and paid for, or is negligent. Maybe the clothes were damaged as a result of his negligence. That is when you hold him responsible, not to return the money you have paid. No, but to pay for negligence. And don't forget, it's only paying for negligence if you are giving him consideration for looking over the item you put in his care. So why? Because the items are specific goods. You enter the shop, you identify the clothes you want to buy, you pull it out from the rest, you agree on it, you even make payment. That is specific goods. So it's your duty to carry your luggage and leave the shop immediately. If you leave it for whatever reason the following day and something happens to it and the item is damaged with no fault of the seller, the buyer is responsible for the loss, not the seller. So you can see the underlying implications of passage of title, whether it is immediate or later, in the nature of each of these classes of goods. Then the second one is ascertained goods. That's the second category, ascertained goods. Now, ascertained goods is a move away from specific goods. And ascertained goods says that, oh, goods that are identified in accordance with the contract after the contract is made. Goods that are identified in accordance with the contract after the contract is made. Goods that are identified in accordance with the agreement after the contract is made. The question is, at what time is the time of identification? Which is very crucial. You can't buy something when you have not identified that thing. You can't buy something when that thing has not been what? Has not been identified. So the only distinction between specific goods and ascertained goods is the time of identification. For specific goods, everything is done at the moment, at that moment. We identify and agree upon it. at that moment. But for certain goods, the time of identification is postponed till after the contract itself. What is the implication of that? If the goods have not been identified or not agreed upon until after the contract, so it means that it really does not come under contract of sale. It's more of agreement to sell, so that liabilities on the part of the buyer may not arise immediately. It will be later when the goods have been identified and agreed upon that responsibility or loss may start to count against the buyer. Then the third one is unascertained goods. Unascertained goods. Now, unascertained goods are goods sold by description, meaning that the goods have neither been identified nor agreed upon by the parties at the time of sale. So goods that are sold by description, yet to be identified, yet to be agreed upon. So if I have a store where I sell food stuff, and I have about 100 bags of rice in my store, and you call me on phone and you say, Folari, I need 10 bags of rice. You need 10 bags of rice. Okay. When are you coming for it? I will come for it tomorrow. Now, I have 100 bags of rice in my shop, and you also know that I have pretty large amount of bags of rice in my shop. Now, we are here to pull out the 10 from the 100. Now, if before the following day that you agree to come to my shop and take delivery, if anything happens to the shop, either it is boggled and they cut away all the rice, or there's a natural disaster, the shop is burnt down, because the 10 bags have not been identified nor agreed upon, there is no liability or bearing of loss on the part of the buyer. The seller will bear the loss. So meaning that contract that you can enter into as far as unascertained goods are concerned is only agreement to sell. Why? Goods are sold by description. When you say goods are sold by description, it implies that the buyer has not seen the goods. And how can you hold me responsible for what I have not seen? However, because the Sale of Goods Act is an old law since 1803, our lawmakers have not deemed it fit to give us a new law. They seem to be busy with other things. But I think in 2014, Lagos State came up with their own Sale of Goods law of Lagos State. But that is only applicable in Lagos, while Sale of Goods Act is applicable to the whole federation. Now, and because it's been made a long time ago, it really does not envisage electronic transaction, e-commerce. Why in 21st century, most of the things we buy are online. We practically do everything online now. You buy shoes online, you buy cars online, whatever you are selling, and you don't have online presence, it's as if you have not started yet. And that is the truth of our time now. So if an item is displayed on any of these outlets online, let's say Jumia, Konga, Temu. I think there was a time some people said, well, Temu, sometimes you order something, and when it comes, it's pretty smaller than what you have ordered. You think that it's bigger and all those things. Now, if you order things online, you click on the items because they are displayed. And now it's been delivered. The question is, can you reject it by saying, oh, it's not a sale, it's an agreement to sell. And I don't think this actually answers or fit into what I think it is. The question is, merely seeing those things online being displayed, does it mean that you have seen it? Does it mean that you have identified it? So that when you click on it, it becomes specific, identified, and agreed upon so that it's binding on you. Even though Sale of Goods Act is silent over that because the Act never envisaged that when it was enacted. I still believe that seeing something online to me does not mean that you have seen it, does not mean that you have identified it. It is still a sale by description. It is still a sale by what? By description. So that by the time you now deliver it to me physically and I look at it and it's different from what you have displayed or what you have led me to believe it is, it is easy for me to reject it without bearing any loss, without being responsible for anything. And it will not be counted as a breach of contract. So unasserted goods simply means goods that are sold by description, goods that are neither agreed upon nor identified at the time of the sale. And under unascertain goods, we have three types of unascertain goods. Number one, we have generic goods. Generic goods simply means goods of the same kind, goods of the same kind. You enter a shop where they sell soft drinks and you say, oh, please give me 10 bottles of Coca-Cola. And they have to pull out 10 bottles from a crate of Coca-Cola. Now, does it matter that they pick the 10 from the front or from the back or from the side of the crate? It does not matter. Whether they pick it from the front row or from the back row or from the side row, it's generic rule. Any 10 will suffice. Until that 10 is pulled out of the crate of 24, it is still unascertain goods in the form of generic goods. Then number two is selling a part of a whole, selling a smaller quantity of a larger quantity. Is also a type of unascertain goods. Just as I said earlier, the example of a storekeeper, a store owner selling food store who has 100 bags of rice in a shop and you just want to buy 10 out of the 100. Yeah, I have placed the order on phone and I said I will come for it the following day. But the point is, you are just buying 10. I have 100 in the shop. I don't know which of the 10 you want. Number one. Number two, I don't even know which of the brands you want. Is it Mama Gold? Is it Cap? Different brands of rice. So there is no way it can be a sale. It will only qualify as an agreement to sell. It is when you get to the shop the following day and you pull out the 10 from the 100. The moment you pull out the 10 from the 100, it means you have identified and you have agreed upon it. It is then that it becomes a sale. Prior to that time, it is not a sale, it is just an agreement to sell. Then the third example under unascertain goods are goods to be manufactured or acquired at a later date. Goods to be manufactured or acquired at a later date. So that is that about the third type of goods called unascertain goods. Number four is existing goods. Number four, existing goods. Now, the focus of existing goods is ownership and possession. And that is why existing goods is defined as goods that are owned and possessed by the seller at the time of the sale. Goods that are owned and possessed by the seller at the time of the sale. So, meaning that the focus of existing goods is really not on whether you have identified it or not. It is more of the seller now. The question being asked is, are you the owner or do you have the possession of the goods? So they don't need to be specific as they can be unascertained. So meaning that existing goods can either be specific goods or unascertained goods. Because the focus of existing goods is on the ownership or possession of the goods by the seller. Then number five category of goods is future goods. Future goods. Future goods simply means this future goods is similar to the third leg of unascertain goods, meaning that goods that are not ready as at the time of the sale, either because they're about or they have not manufactured it, or even the seller himself has not acquired it. He still has to go to his own customer to acquire it before he brings it to you. Now, future goods are goods to be manufactured or acquired by the seller at a later time after the contract of sale. So by design, you'll have known that future goods also can only come under agreement to sell, not a contract or a natural sale, so to say. Now, these are the preliminary issues to note about sale of goods. We talked about introduction, we talked about definition, we talked about sale versus agreement to sell. We have looked at the subject matter of sale of goods, which is the goods. We looked at the definition. We have looked at the different classifications or categories of goods. We still have a few minutes left, so maybe in the next few minutes I can cover formalities and price determination. Now, talking about formalities, the question here is that does the law require that sale of goods transaction must take a particular form? Must it be in writing? Must it be signed, sealed, and delivered? Can it be verbal? Can it be oral? Now, talking about formalities, the law is silent about whether a sale of goods transaction to take a particular format. No. As I said at the introductory stage, the bulk of a sale of goods agreement or contract are majorly unwritten, majorly verbal, oral, and even by conduct. So the law does not say that when you are buying something from anybody, you must do an agreement and must be signed. No law says that when you are buying a car, there must be a written agreement from the seller to the buyer. But for practical purposes, you collect documents of the car. Sometimes you need to do change of ownership. You go to go get a lawyer who will help you with change of ownership if it's a Nigerian used one. And of course, the seller has collected money for the car, will issue receipt. All these are evidence that a transaction has taken place. But that is not to say that the law says that you must do agreement for sale of car between Mr. A and Mr. B, that Mr. A will sign on the one hand and Mr. B will sign on the one hand. You can do it. It is just surplusage. If anything happens, that does not mean that the agreement is not enforceable. It's enforceable, even though it is oral. So then capacity. Now, I believe that you'll have been taught capacity under the law of contract that you have done before now. The rule of capacity under sale of goods is the same rule with the one in the law of contract, meaning that buyer and seller must have capacity to enter into an enforceable contract, meaning that you must be of age. And age of majority or majority in Nigeria is 18 years. It used to be 21 years before, but now it's 18 years. So anybody that is below 18 years is an infant. And under the law, you cannot enter into an enforceable contract except in exceptional instances, like where what minor or the infant is buying are necessary goods, that is goods that are needed for the survival of the child, like food or basic clothing. So in that case, the parents or the guardians will be made to pay for it. But if what the infant has bought is a luxurious item, then the contract is not enforceable against him. So the same rule of capacity under law of contract is the same that's applicable in sale of goods. Lastly, is determination of price. I said it earlier that when you're talking about price, that is a consideration under sale of goods. And Section 62 has clearly made it clear that it is for a money consideration called the price. So mean that consideration or what you have given in exchange for what you are getting must be money consideration. That's the general rule. So it's not trade by barter. You cannot pay in kind. You just have to transfer that money or reach around into your wallet or pocket and bring out cash and pay. However, there are only instances that that rule can be a little bit uh, uh, um, exempted. For instance, where there's something we call trade in, where you pay partly in money and partly in goods. But it does not mean that you are paying goods for goods. No, partly in money and partly in goods. For instance, if I have a regular car dealer I use and I bought, say, Toyota Highlander 2006 from my car dealer 5 years ago, and having enjoyed the car for 5 years, I want to upgrade to uh, Toyota Highlander 2017. And I approach him, I say, guy, I want to upgrade. I want to buy Highlander 2017. I am tired of this Highlander 2006. How much is your Highlander 2017? If he says, okay, take it for 20 million. Okay, I don't have 20 million. Okay, this Highlander 2006 you sold to me 5 years ago. It's in a very good condition, still neat. Please come and value it. How much can you buy it? And he looks at it, okay, I can take it for 6 million. Okay, can take it for 6 million. Okay, deduct 6 million from 20 million. That's 14 million. I'm going to pay you 14 million. Take 14 million and take my old model Toyota Highlander. Now, that will still come under money consideration. That is partly goods, partly money. But transaction or trade by barter, giving goods in exchange for goods, will not be covered by sale of goods act. Now, the next question is, how do we determine the price? You see, it is taken for granted, and that is Section 8 of Sale of Goods Act. Section 8 of Sale of Goods Act, that price can be fixed in 3 or 4 ways. Number one, the contract itself can fix the price. You enter into a contract for somebody with somebody, and you've already put it as part of the terms of the contract. The price is 1 million naira. The contract itself has fixed the price. That is, you have included it as a term in the contract. So, number one way you can fix the price or you can determine price is fixing the price by the contract itself, number one. Number two, where you fail to state the price of the contract, then in an agreed manner by the parties. That is, both parties may say, okay, in this agreed manner, price will be determined. They can say, okay, don't worry, by the time we are ready to pay, we can consult Mr. C. Mr. C will determine what the price is for us. Probably because Mr. C is a professional in that area, and such transaction is such that prices fluctuate and all that. Okay, don't worry, when it's time to pay, we call Mr. C, who will tell us what the current market price is. So, in a manner agreed upon by the party, by the buyer and the seller. So, price can be determined that way. And where that also is not stated by the parties to the contract. The third way is in the course of dealings by the party. In the course of dealing by the parties can also determine the price. For instance, I've always bought, say, shoes from you, and you know the amount I always pay. The price is fixed. I still bought one barely 2 weeks ago, and I want to believe that within 2 weeks and now, nothing should have changed. And 2 weeks later, I'm asking for the same type of shoes. You are now moving the price from 50,000 naira to 120,000 naira. And you drag yourself to court. The court will say, at least the cost of transaction between both of you should help you to determine the price. Yeah, we know that the market we have now is very, very unpredictable. You go to market yesterday, you get something for a price. Today is another thing entirely. But again, the court taking that into cognizance will still make sure that the gap is not that wide, especially if that item is not such that it is known for constant or regular fluctuation of prices. So the cost of dealing between the parties can also assist to determine what the price is. And lastly, which is number 4, is where the contract has failed to fix the price, where there is no agreed manner between the parties to fix the price, and where there's no cause of dealing between the parties that can let them decide or determine what the price is. The last resort is what we call reasonable price. The court will impose a reasonable price on the buyer. Once there is evidence that there's actually a transaction, you have to pay something. If for whatever reason you fail to fix what the price is, then the court will say, pay a reasonable amount, and the court will fix a reasonable amount. But the idea of a reasonable amount is influenced by so many factors, like what is the nature of the goods itself? Are the goods perishable goods or non-perishable goods, which may impact on the price of the goods? Number 2, factors like, are these goods as such that the price usually fluctuates in the market? Yes or no? It will help to determine what reasonable price is. Then is it also a type of item that is in high demand or low demand, as the case may be? So the court will put all these factors into consideration before determining what a reasonable price will be. If the item is such that it's in high demand in the market, you can easily understand when the court says reasonable price will be high. But if the market is a type of item that the demands are low, the seller cannot be asking for something that is so high. Court will say, if we turn this item to you, you know how long it will stay in your shop before you get it sold or get a customer to buy it. So all these factors put together will help the court to determine what a reasonable price will be. So I think at this junction, this is a convenient point to rest for today. We'll continue next week. Class rep, please, you need to reach out to me so that we can begin to talk about arranging for your CA. Please, any comments, observations for 1 minute from the class? Please, if you have comments, observation, or question, please signify by raising your hand electronically. You just take 1 or 2. Okay, let me take these first 3. Let me start with Ba Eyi. Is that Barrister Eyi or Eyi? Eyi, over to you.
Good evening, sir.
Good evening.
Good evening, Prof, sir. Thank you very much, sir.
You are welcome, sir.
Yeah. My question is coming under the future goods you mentioned earlier.
Okay.
So I'm a bit confused there in the sense that let me paint a scenario so that will be able to help you to prove my question out.
Okay.
You said future goods are goods that you paid for that you cannot easily have access to. Maybe they deliver in future.
I didn't say you have paid. I didn't say you have got nothing like
okay. Paid. Oh, you don't make payment for future goods, sir?
Continue your question. I will explain.
Okay, so my question is, if I should pay for goods that should be delivered next week as a future, maybe I paid and they say, oh, it's not available to be available next week or 2 weeks' time. And in the process of delivering to me, something happened and they could not deliver, maybe an accident or whatever happened along the way. My question now is that who is to bear the cost? That's my question, sir.
You collect your money back. You collect your money back from the seller. You see, that's why I said that I never talked about payment when I was explaining future goods. What I emphasize is identifying and agreeing upon it. In fact, in truth, payment or no payment has no great impact on determination of passage of property from the seller to the buyer. No. Now, the law is not saying that you're not going to pay. Sure, you're going to pay. But that is not the major consideration when you want to determine whether a contract is an outright sale or is an agreement to sell. No, that's not the determining factor. If payment were to be a determining factor, credit sale, credit sale, conditional sale will never have come under a sale. Hey, I don't know whether you are listening to me. Because under credit sale, you have not sold. I mean, you have not paid, or probably you have not paid in full. But property has moved to you as the buyer. And if anything happens, it's your loss, not the loss of the seller. The seller will collect his full money. And yet, payment has not been paid, I mean, has not been made, or full payment has not been made. So the law really does not celebrate payment that much when it comes to determination of when property passes from the seller to the buyer. Suffice to say that the goods have been identified and agreed upon. And at that point, property will move from this buyer, from the seller to the buyer. Now, in the scenario you painted, you have not seen the goods, but you have made payment for it. If you bring it with this explanation I made now, yet in the eye of the law, if the goods have not been identified or agreed upon, if anything happens to it, the loss is not your own as a buyer. The loss is the loss of the seller. Collect your money back. Hey, am I clear? Hey, are you still there? Am I clear? Okay. Charles Mwabweze, over to you. Charles.
Okay, good evening, sir.
Yeah, good evening.
Yeah, so my question is in between ascertained goods and unascertained goods.
Okay.
So you outrightly said for specific goods now, you said as long as the contract has been made, the buyer has made the purchase, so the buyer bears full responsibility of the goods. But for ascertained and unascertained goods, at what instance or at what point does the buyer take responsibility of the goods or bears the risks of the goods? For instance, if anything happens to the goods in the shop of the seller, at what point does the buyer take responsibility of the goods?
He does not take responsibility of the goods. You see, unascertained goods says that the goods are sold by description. The buyer has not seen it. And if he has not seen it, it means that the goods have neither been identified nor agreed upon. Now, for ascertained goods, they are goods that are identified in accordance with the agreement, but after the sale, not before the sale, unlike specific goods that is before the sale or at the moment of the sale. Now, anything that happens after the sale implies that, oh, it is not a sale yet, it's an agreement to sell. So if the goods are neither identified, as in the case of ascertained goods, nor agreed upon in the case of unascertained goods, the implication still remains that risk and loss are yet to move to the buyer. They are still with the seller. Now, risk and loss will move to the buyer when it now comes later to pull out or to identify the ones he wants to buy from the bulk in the shop of the seller, and he puts it out from the rest. At that moment in time, it becomes identified, agreed upon. Then, from that moment, payment is made, then it will bear the loss if anything happens in terms of damage. But please don't forget that all these explanations are outside instances where there is insurance on the goods, depending on the nature of the goods. It's outside instances of what do we call it? Consumer protection laws. Remember, we have consumer protection laws. It's also outside instances of warranties. There are some items you buy and they give you 1 year warranty. If anything happens to it, you can return it and take another, or they can give you another a part to replace a part of the item that is. So it is outside all these three. So if there's a warranty, then it means that the buyer has indemnified himself, can always come back and ask for another one. And if there's insurance, of course, you know that that will be the responsibility of the insurance if it has enough coverage. And consumer protection laws, which is there to protect consumers. So if I buy something from you, I now say because it has been identified, agreed upon, and I take it to the house and I see that what you have sold to me is of very poor or low quality. You cannot say because property has passed to me, you will not. No, consumer protection law can come to protect me in that instance. And we have consumer protections commission in Nigeria. But that is not our focus. When we get, maybe next week, when we get to fitness for purpose, say by description, you will understand some of these nuances better. So thank you, Nwabuse. I hope I've answered your question. Paul Esiogene, George, over to you, please.
Good evening, sir. So my
Good.
question is on this scenario, whereby at what time would trade by barter be a consideration for maybe a service that's rendered? What I'm trying to understand whereby trade by barter can be used as against payments, like maybe for the goods instead of paying cash, and you're using trade by barter to transact. In what situation will you put that?
Thank you very much. You see, number one, trade by barter is not covered by the sale of goods. When you are paying for goods, you pay money, or partly money, partly goods, which is an exception anyways. When you now say using goods to pay for services, sale of goods does not cover services. What covers services in Nigeria is a Labor Act of 1974. So that's a law that governs provision of services from service provider to the consumer, or between the employer and employee. Now, that scenario is outside the scope of a sale of goods. So there is no time that you can use goods to pay for services. In fact, even under Labor Act, if you look at Labor Act of 1974 very well, it makes it clear that you have to pay your employees their salaries. You have to pay them their salaries, which it means that you pay them money for their salary, not that you pay them goods. There can be allowances like you give them official car, you give them you give them accommodation and things like that. But majorly, also their salary will be in money. There can just be some other benefit attached to which can come by way of in kind. But that is not to say that that will not be their total remuneration or emolument. But again, that is under labor law, which is under the scope of a sale of goods act. So I don't know whether I've answered your question, Paul. The last person.
It's halfway, because I encountered a situation whereby, okay, so let me just give you a paint situation that really happened. Okay, so I did a transaction with Cool FM, for example. I used to work in a media house, which is like an outdoor industry.
You don't need to mention their names. Just say you did the work for.
Okay. So I did a transaction with a radio station whereby the radio station wanted exposure on the bill.
Hello? Paul, we have lost you. Your connection is unstable.
Let me state myself again. So what I said is this. So the radio station wanted a service they wanted to be exposed on a billboard, and they didn't want to pay cash for that service. So they transacted. The transaction was, and it was a contract. We actually had a contract that stated that, okay, they would give us exposure. No, they would give us airtime on the radio station to pay for the exposure on the billboard, whereby we can sell the airtime as a media agency. And that transaction actually existed, and it was sealed.
Okay. But that's what both parties agreed on.
Okay.
As in Paul, as in both parties agree on that.
Okay.
No, I'm asking both parties.
Yes. Both parties agreed on it. Yes.
Okay, we expose you on a billboard and you give us
Airtime.
airtime you can sell. What the law will focus on is what is the value of the airtime. So
Yes, so we actually put a value to it.
So once you put value to it, one, it doesn't come under, with your further explanation now, it doesn't come under sale of goods act, it doesn't come under labor act, but it comes under normal contract. And under normal contract, anything goes. You can use goods to pay, you can use. So since you are provided billboard exposure for them, and they have paid in airtime which you have placed a value on. So just like the case of the Korean missile, the court will just look at the value. And don't forget, under law of contract, consideration is anything that you can attach value to. Anything that has value will fly. So it will fly under normal contract. But not under
sir.
the labor law. So thank you very much. The last question. In that dossier, your question, please, in 1 minute.
Good evening, sir. Thank you for the session, sir. Yes, thank you, sir. So please, in the course of the class, you gave us 3 types of goods. You made mention of you said the first one, second one, and then the third one. So from what I have here, second one is fruit juice.
That's the under definition of goods. That's the under definition of goods. Under that definition, sir. Number 1, we have personal items. That's number 1. Now, under personal items, it now says remove intangible items. That is, intangible items are not captured under personal items. That is, remove anything like intellectual property, anything like copyright, like a patent, like a trademark, like industrial design, remove them. Anything like shares, like debentures, all those things, remove them. They don't come under personal items. Then it also says you should remove money. Once that money is still a currency, it doesn't come under personal items. And lastly, it says you should also remove real property. Real property does not come under personal items. So number 1 is personal items with the deduction of all these I've mentioned, then followed by emoluments. Then number 3, industrial growing crops. Number 4, things attached to or forming part of the land. Now, industrial growing crops is a fruitus industrialis, while things attached to or forming part of the land is fruitus naturalis. Is it clear now?
So what do you call the first one? Is implement or enablement?
Emoluments.
I need the spelling, sir.
EMBLEMENS.
Yes, okay.
MENTS. Emoluments.
Okay, thank you, sir. Thank you, sir. Thank you.
Thank you very much. Please have a wonderful night rest. Bye-bye.